Thank you, Patricia. Good afternoon, everyone. Thank you all for taking the time to join us for today's webinar on highly qualified representation in juvenile and family courts. My name is Andrew Wachter. I'm a site manager for the Child Welfare and Juvenile Law Department at the National Council of Juvenile and Family Court Judges. Today's webinar will be presented by myself, as well as Mimi Laver, the Director of Legal Education at the ABA Center on Children and Law, and Jay Rajamaran from the Legal Services of New Jersey. I will be talking a little bit about high-quality legal representation from the Enhanced Resource Guidelines perspective, while Mimi will be talking more about the importance of high-quality legal representation for parents and what it looks like, and Jay will discuss the practice of assigning attorneys pre-petition in New Jersey. Today's webinar is supported by funds from the Office of Juvenile Justice and Delinquency Prevention. Their vision is a nation where children are free from crime and violence, and if they come into contact with the justice system, that contact should be both just and beneficial to them. Their mission is to develop and implement an effective and equitable juvenile justice system that enhances public safety, ensures youth are held appropriately accountable to both crime victims and communities, and empower youth to live productive, law-abiding lives. And lastly, I need to mention that the points of view expressed today by myself as well as the other presenters do not necessarily represent those of OJJDP. Today's webinar is hosted by NCJFCJ, one of the largest and oldest judicial membership organizations in the nation, serving professionals in the juvenile and family justice system. The NCJFCJ provides the resources, knowledge, and training to improve the lives of families and children seeking justice. We have 3 learning objectives for today's webinar. The webinar is designed to help you understand the principle of highly qualified representation from the Enhanced Resource Guidelines, also to learn important elements of highly qualified legal representation and how it affects children and families, and lastly, we will share ways to appoint counsel early in the case and the important reasons for doing so. To begin our discussion today, I wanted to talk a little bit about the Enhanced Resource Guidelines and what they recommend regarding legal representation. The Enhanced Resource Guidelines serve as the blueprint for NCJFCJ's effort to provide training and technical assistance to judges presiding over child abuse and neglect cases in courts across the country. Many of you that have joined us today are ERG implementation project sites, so I thought it would be a good place to start and provide a brief refresher on the topic. The Enhanced Resource Guidelines include 10 key principles, of which one is to ensure competent and adequately compensated representation. This principle asserts that judges have a responsibility to ensure the attorneys practicing in their courtrooms are well-trained and well-compensated, and that they vigorously represent their clients. This principle urges judges to take a leadership and oversight role to work with attorneys or their agency to advocate for routine and ongoing training opportunities and work with state legislators and local governing bodies to ensure sufficient funding for attorneys. Furthermore, judges should ensure that children are parties to their cases and that they receive representation by attorneys and guardian ad litem to ensure that the children's wishes are presented to the court. This philosophy is consistent with the view that children's legal service needs are best met by both a client-directed or expressed wishes and advocate-directed or best interest models of representation. Highly qualified legal representation is a critical element of a well-functioning child welfare system that's designed to improve the lives of children and families. This segues nicely into a brief discussion about areas in which attorneys should be trained. The Enhanced Resource Guidelines include a long list of topics on page 43 and 44, but I wanted to highlight a few of them here today. And just to pause, I referenced the Enhanced Resource Guidelines numerous times today. That the PDF of the resource guidelines is available in the bottom file pod. You can click and download that yourself. So attorneys should receive ongoing training on relevant state, federal, and case law on abuse and neglect cases, including parental termination laws. They should also be familiar with state and federal benefit programs available to those in the child welfare system. Knowledge of the Indian Child Welfare Act, or ICWA, is very important as well, as state laws related to Native Americans, and the guidelines set forth by the Bureau of Indian Affairs, and know the differences between reasonable and active efforts. Lastly, attorneys should be trained and familiar with immigration and education law in child welfare cases. Next, I'd like to highlight a few of the practices that the Enhanced Resource Guidelines recommend for attorneys practicing in child welfare cases. The full list of those practices are available on pages 45 and 46 in the Enhanced Resource Guidelines. Because critically important decisions are made at the very first hearing, parents should be represented by counsel as early in the process as possible. This includes representing them pre-petition where possible, and the same attorney should continue throughout all stages of the case. The court should work with attorneys who practice before the court to develop a system of appointment sufficiently in advance of the preliminary hearing to permit meaningful consultation and preparation. At each hearing, the judge should ensure that parents have had sufficient opportunity to consult with counsel and that counsel is prepared to advocate on their behalf. This can be done by asking parents if they've had enough time to meet with their attorney prior to the hearing. Attorneys should also participate in any alternative dispute resolution efforts, such as settlement conferences or mediation, and in case conferencing efforts like family team meetings or family decision-making conferences. They should thoroughly investigate the case at every stage of the proceeding and review all documents that have been submitted to the court. Attorneys should know, among other things, the family's prior contact with the child welfare agency, who made the decision to bring the case to court, the basis for agency intervention, including the specific harm that state intervention is supposed to prevent, and what alternatives, such as voluntary in-home services and placement with relatives, were considered prior to initiating court proceedings. Lastly, attorneys play a vital role in the court process and therefore should be invited to participate in any collaborative efforts that focus on overall court improvement efforts. Before we move on, I wanted to ask some questions. We have two polls for the audience regarding when attorneys are appointed in their jurisdiction. So you can see Patricia has put a poll up for the attendees to answer. We're asking the question, do you appoint representation for all parents, both custodial and non-custodial, in child welfare cases? It's a yes-no question. We're getting some results there. Overwhelmingly, it looks like the answer is yes. Just shy of 10% have indicated no. Patricia, you can go ahead and close that poll. Thank you. So overwhelmingly, attendees indicated that they are providing representation for all parents in child welfare cases. The second poll question focuses on at what point in the case does that happen. So we have some timeline options here for you to select from. So when do you appoint representation for parents in child welfare cases? The options are before the petition is even filed, at the time that the petition is filed, at the initial shelter hearing, at the adjudication hearing, at TPR, or if there's some other time in which you typically assign attorneys to parents, feel free to write that in the chat box if one of those options doesn't fit your situation. So the majority of people are responding here fairly early in the case, either when the petition is filed or at the hearing. It looks like about a little over 50% is at the initial hearing, and just shy of 50% is when the petition is filed. Patricia, you can go ahead and close that poll. Thank you all for those polling answers. That information is really useful to us as we continue. I'd like to now turn the discussion over to Mimi Laver, the Director of Legal Representation at the American Bar Association Center on Children and the Law, to talk more about what high-quality representation looks like.
Hi, everyone. Thank you, Andrew. Nice to be with all of you today, and I really really appreciate that you joined us. I know that all of you are so busy during this crisis, this health crisis, and the crisis for the families that you all are serving. And so I appreciate that you spent the time with Jay and me today. And we will be talking a little bit about what is high-quality legal representation for parents and a little bit about high-quality representation for children. And also, Jay is doing on-the-ground representation every day and does practice in a model where some of her cases, she gets the case before the petition is even filed, which is why Andrew asked that question earlier. And by the end of the call, we're certainly hoping that those of you who don't appoint until the shelter hearing can start to think about how to appoint even before that hearing. And I was really happy to see on the poll that none of you were appointing after. So that is not representative necessarily of courts across the country, but I'm really pleased to know that it is representative of these ERG courts and those of you that are interested in this topic. So I know some of you, and I'm happy to be reacquainted, but for the rest of you, my name, again, is Mimi Laver, and I work at the ABA Center on Children and the Law. We are sort of one of the nonprofit centers at the larger American Bar Association. There are about 16 of us, and we all function on grant funding. We and are here to serve lawyers and judges all across the child welfare and child serving communities. And you can see our goals. I'm not going to read you slides because you all can read. And one of the projects that I work on, almost all of my work is focused on representation. I lead the National Alliance for Parent Representation, and I'm a co-lead on the Family Justice Initiative. And I think the motto of the Family Justice Initiative is really very important for this conversation, which is why I will read this one, that we want to ensure that every parent and every child has high-quality legal representation when child welfare courts make life-changing decisions about their families. And you as judges, and I know that some of you are lawyers providing high-quality representation, but you as judges in the National Council have a huge role to play to help us meet this goal of ensuring that everybody who's involved in the system, both parents and children, have high-quality representation. And the FJI is a collaborative of parents' attorneys and children's attorneys from across the country, along with Casey Family Programs, the ABA, the Children's Law Center of California, and currently the Washington Office of Public Defense are the lead organizations. But we've been working with parents and children's attorneys all across the country to come up with what we believe really is the definition of high-quality representation. And so what you see on the slide right now is where we landed. We landed to describe that there are fundamentals of high-quality legal representation, that every parent and every child has a right to counsel, and that they need to do all of the basics of being a lawyer, right? Filing motions, doing all of the things that we all learned in law school. But then there are certain pieces that we really wanted to pull out. So what we called them attorney attributes for those issues that individual attorneys could handle on their own, and system attributes that take the entire group of stakeholders, often under the lead of the judge, to make a reality. And a few, I'm not going to, again, read them all to you, but a couple that I really wanted to highlight before we allow Jay to talk about her practice is this issue of out-of-court advocacy. And now, during this crisis, when courts are slowed down, if not shut down, and lawyers can't see clients, as well as in the more normal times, out-of-court advocacy to me is the most important piece, even in many cases more important than in-court advocacy, to make sure that parents and children receive the services, the help, the visitation, all of the reasonable efforts that they need to be able to keep their families together, and in cases where families need to be separated, this out-of-court advocacy by lawyers is what leads to being safely reunified. And then you'll see the system attributes. They're all really important, but I've highlighted for you interdisciplinary representation because that is a model of representation that not too many places in the country are using, although more and more, I'm happy to say. And that involves a lawyer, a social worker, and someone with lived experience as part of the legal team. So in some places they call them peer mentors, parent allies, but people who can wrap around the client, whether it be the parent or the child, but here we're talking about the parent, wrap around the parent client to be able to ensure advocacy within the agency, within the court, access to services, housing, whatever the issues are. So these are the elements that we think of as high-quality legal representation. Again, we had consensus on this from advocates all across the country. You can see in your web link that the FJI high-quality attributes are linked. It's a document that sort of describes all of these attributes. And now I'm going to ask Jay to pick up a little bit and talk about her practice and how she provides early representation in cases. And she, I know, will really talk a little bit more about the out-of-court advocacy.
Thank you, Mimi and Andrew. Good afternoon, everyone. So again, my name is Jay Rajaraman, and I run the Family Representation Project at Legal Services of New Jersey. Just quickly, as way of background, we represent parents, aged out youth, youth in the system, kin. We like to say that we do have a very developed representation project, both post-petition and now extensively prevention. So I'll focus on that, the pre-petition work, as well as post-petition work and how they're connected. We also have followed the ABA model that was identified earlier by Mimi as being a multidisciplinary model. So we have our attorneys, social workers, and a parent ally. And also very fortunate that we have interpreters in our legal services system as well, all on site and available to our families. And I've been happy to do this work and love being a parent's attorney for the last 15 years at Legal Services. And then prior to that, I've worked in a model that did not provide the multidisciplinary system at the Public Defender's Office. So I've seen both. And again, thank you for taking this time with us, knowing, understanding that COVID-19 is existing not only for your daily lives, but for our families. So I will do my best to give some real examples and some of our advocacy and what we've been doing on the ground the last 3 to 4 weeks under this crisis for our families, including the out-of-work court work. So just to back up, as we know, just talking about legal services and looking at the Family First system, as I know many of the attendees are aware of, the last few years there's been a lot of national changes in legislation, specifically with Family First Act. And I'm not going to spend time talking about that act or the details, but what that had done, even if it may not have changed practice or funding for your state or jurisdiction, it did strike a chord across the nation about looking at Family First and examining how children become involved in the child welfare system. And as for a parent's attorney, this conversation and advocacy has been going on for decades, right? We are all well aware of how our families become involved in the child welfare system and how the majority of the families that are involved with the system deal with allegations of neglect. And when you dive in further into that subset, when you identify things as neglect or things are being coded as neglect, we're really talking about poverty. We're talking about lack of housing, access to food, food insecurity, housing instability, education, no child daycare systems. These are the factors and realities for our families that become an involvement issue for our families that deal with the child welfare system, and maybe even a reason for having their children removed. And so what has occurred in the last few years with our efforts nationally and in several jurisdictions really is that if we realize that these are poverty issues and we can sort of stabilize and prevent these removals through supportive systems, and we keep children and families together, because we now know that that is a known trauma and that's accepted as an understanding through data and science is that when possible, you would try to prevent trauma for our families, especially for children. And so what do we do as advocates to do that? What can we do, understanding that we should be doing everything possible to prevent removal, to reduce trauma, and stabilize these families? So what we have done in New Jersey and what our model practice has been is actually focus on the prevention, the pre-litigation work. I'm partnering with the Child Welfare Agency in New Jersey. So our system right now is actually getting referrals from our Child Welfare Agency, advising us and requesting legal assistance, actually having attorneys assigned to these families, advocating for these families in these poverty-related issues. So instead of where in practice it had occurred before, and still occurs in New Jersey, but when an agency would become involved with a family and they're about to be evicted or not have funding support for that housing unit, or unable to access food or were unemployed, and after a period of time, the agency may decide to remove and say that family is unable to provide for their children and remove and have the child placed in the system. They are now referring those cases to us at Legal Services of New Jersey. And our practice right now is that we get these direct referrals from the agency, not only from the agency, from judges, from the other advocates in the system, and we do an immediate referral system and intake within 24 hours. And then we assign them to an advocate, social worker, and when necessary, the parent ally for these cases. And we, within 24 hours, we try to assess what are the legal issues and be able to work with them in providing legal advocacy as to those housing poverty-related issues as quickly as possible, within really 24 to 48 hours. And why this works is that it's a very parent-focused supportive technique. So what happens is that once we receive the referral, we decide that we're advocating for this client if they qualify, there's no conflict, and then we work with that parent quickly and urgently to make sure we're resolving whatever ancillary legal issue that red flagged them to become involved in the child welfare system. And now, just to note, we've done this work actually longer than the last 2 years. The project has really evolved in this referral system, but prior to this, we have a hotline, we have an email, an intake system, where many families would call legal services and say, I don't know what to do. The agency is knocking on my door. Do I have to talk to them? What are my rights? Do I have to sign a release? They're asking me to do a drug test. They wanted to interview my child. What are my rights? So this practice of informing the community of their legal rights and their options has been developed in New Jersey almost over 50 years through legal services. This belief that you should know what your rights are when you're dealing with any state agency. So from welfare to the child welfare system to education, we're making sure they're informed with information and know what their rights are so they're best prepared and feel comfortable and confident in responding to the issues that they're dealing with, especially when they believe their children could be removed or taken from them if they don't sign that release or they don't understand their issues to safety planning. So that's been a large part of our work. The difference that has occurred the past 2 years is this direct referral that we actually are partnering with the agency where they believe that they want to resolve the legal issues so they don't have to file these petitions. So I identified it in the last slide, but I just want to make sure we hit on some of the points that makes this prevention model what we think has been effective. Every referral has a social worker assigned to. This has been critical, understanding all the resource and barriers, blocks that occur in our jurisdiction. So from understanding welfare, the housing limitations, being able to find resources for our families has been a large part of the reliance on our social workers. In addition to, as we know, our families face severe anxiety, mental health, other limitations that affect their child welfare case, in addition to all the other silos that they are intersecting with. And so social workers have been incredibly helpful and are my partner, my go-to in every case, accessing resources for our families. Having a peer ally has been also incredibly effective. No one can connect more so than a parent who has gone through the system. And we have this incredible parent, Aisha. She actually faced termination of parental rights 3 times and had her children removed from her for over a period of 5 years. And she was successful in getting her children returned to her. And now she's in the process of becoming a nurse in addition to doing this peer ally work with our office. And she has been able to be our community tie, our connection. So she knows resources in the urban areas that our social workers don't have access to, the court systems don't have access to. She's able to figure out what neighborhoods are safe for certain children or what's closer to a playground that's more beneficial to a child. She's been just completely incredible and such a supportive factor in our model. And some things to note that we identify and put great importance in our model. It's the trauma and grief-informed practices. We have to remember that every time we get an intake, that this phone call and this individual has so much more history than that can be expressed in the few minutes referral that we get from her caseworker, his or her caseworker. And so we have the social workers to assist with that way, but also how we serve that parent. So within those 24 hours from that intake, we spend a great deal of time trying to build trust with that individual. Often we have parents who will call us or they speak to us because they know they're being referred to us from the agency, and they just don't trust us. They think this is another barrier or another hurdle to jump over or through just so they can keep their agency caseworker happy or prevent a removal. So we have to explain to them that we're here as their advocate. We're going to spend time arguing for them and advocating for them, and that they're our boss. We're working for you. This is confidential. There is no reason why we have to return to the agency except if we are going to advocate and prevent a removal. And that takes a lot of time that often we don't have, but that is something we've become quite fluid in, just because that was the initial issue, is that how do we get parents to trust and engage with them effectively? And that's really part in learning trauma and grief-informed practices, and also taking into account cultural competency. And that goes into, again, our language, our culture, understanding the community, meeting with families in places that they feel comfortable. We text with our clients, we email with our clients, we create atmospheres and places where they feel comfortable and confident that we're here advocating for them and not just another arm of the agency. And that's what our prevention project has been. We've now, in the last 2 years, we've had over 130 cases, and I'm happy to report that we've not had any removals. We've had over 230 children have remained with their families stable, and we've been able to assess in these poverty issues, ancillary issues, through legal advocacy. And what's critical not only is the referral and working with the agency, is to know that there's so many regulations and statutes and case laws and parameters in your jurisdiction when you have an agency involved, child welfare agency involved family. There's a lot of exceptions and protections that can assist that family to resolve these poverty issues. So for example, having a division-involved family in a welfare case is an exception to causing your own homelessness or getting better access to housing. You actually get onto maybe a better wait list, or you get priority. And what we've learned during this work is a lot of housing offices don't know this, the agency doesn't know this. And so when we do this and connect the legal issue and say, look, actually getting a letter from the child welfare caseworker and sending that to the welfare office has now stabilized their welfare, and they have access to emergency assistance, rental assistance, cash assistance, food assistance, and that is just with our advocacy. We've been able to do some incredible prevention work from not losing certain vouchers. Again, it's connecting that child welfare case to the housing or the welfare issue. This has come up with domestic violence, education, immigration. There's exceptions under immigration law. That it's this intersection that's been really critical. And so it's keeping on top of not only the housing and poverty issue involved issues, but also keeping the child welfare agency up to speed and keeping them accountable for what they're required to do to support their affirmative duties under federal and state law to support that family prior to removal. As we know, reasonable efforts, but often a lot of our statutes actually call it affirmative duties. What are they required to do to support this family? Okay, so I spent time talking about the prevention. I just want to take a note of recent situations with COVID-19. As many jurisdictions across the country, there are directives halting evictions and where you can't file for evictions can't be effectuated. So we have actually been working with the Child Welfare Agency and providing housing, even if it's a motel or shelter, but able, again, to support these families so they remain where they are. As we know, everyone's been losing their jobs. They're not able to pay rent, but there has to be information out there not only to the advocates or to the child welfare agencies, but also to the landlords, because their landlords are still threatening to evict or provide false information. We've had clients been threatened to say that you'll owe 2 or 3 times more rent because of the certain situation, because of the coronavirus. And so we've been advocating to prevent those issues from occurring, to affect families and where they're not being kicked out of housing or physically being kicked out, which is always in violation of certain housing laws, but it's increased since coronavirus has occurred. And then assisting the Child Welfare Agency to be a better advocate on the other end in these situations. And so if you don't, I know many of the jurisdictions do not appoint or do not have access to legal advocacy prior to removal. It doesn't mean this is not helpful to know this information. In fact, now I do a lot of post-removal and post-petition work, and now doing prevention work, I can actually report or argue more effectively of what the agency is required to do for reasonable efforts post-petition. And I've had many conversations with judges, on the record and off the record, that it's helpful to know this information of what the agency has access to pre-petition, what's really required for them to stabilize and assist these families. And prior to doing this work, I really did not have a full understanding of how much the agency can provide and stabilize and reduce the coding of neglect or reduce the concern of neglect for families when they are fulfilling their duties as I had described. And so it's been helpful when there are cases when I become involved in post-petition to be able to raise these issues on cross-examination, on motion practice, on practical case examples where I'm raising whether or not the agency complied with reasonable efforts or provided these assistance to the family, as we now know is available to the Child Welfare Agency. And so I've had many judges say to me and learned that I just thought there was a certain type of voucher. I didn't realize welfare could do this, or I didn't realize that there was this exception, or I didn't understand what this meant if they were to receive unemployment and they needed a letter from the Child Welfare Agency or a certain order. So it's been so critical to understand what's available pre-petition. So when you have these cases post-petition, you actually can assert what's required both for the family and the agency. And so this has been critical in my COVID-19 practice. Just quickly, I had 2 examples where we've actually seen an increase of hospital holds where children, newborns were asked to stay at a hospital, and the agency requested to remove because mom had a prior addiction history and was living at a shelter. And the agency suggested that the shelter would be more likely to transmit COVID-19 to the twin newborns. It was unstable, and also laid out her addiction history and her past instability to provide housing. The children tested negative for any drug use, and mom is actually in a successful recovery process. And so we were successful to have the twins return to mom because we were able to show that the shelter did have a family room, and she was separate from all the other shelter families, and it was as stable as any housing unit that you could ask for, in addition to showing what the agency failed to do, which was provide appropriate housing, getting this mom into other systems of drug treatment and different other programs. Mom was in her own recovery program that we were able to find through our social workers. So it was just our proactive efforts of showing that this was a stable shelter, getting letters from the shelter. Also, we really stressed the bonding that was needed between the twins and mom. She was also nursing, breastfeeding the children, the skin-to-skin, all the medical information, data was provided to the judge. And so finally the judge did agree that was what was safe for the children. It was not only safe, but COVID-19 would not affect the safety of the twins' health or mom's health. And in fact, it would be damaging to the children not to be with their mother because she was nursing, and her providing nursing would improve their immune system. And we were able to get all this information in, and it was really a lot of my prevention work that sort of supplied me with this information to assist post-petition. Okay. The other example just last week was a reunification case. In your materials, I just wanted to note we do have federal guidance issued by the Children's Bureau as to having parenting time, that that parenting time is still important. There shouldn't be blanket rules, denying parenting time, alternatives to face-to-face parenting time and visitation. And in that guidance, it also highlights there should not be delays in reunification. And based on that Children's Bureau guidance and some of the things that Mimi hit on through the ABA and the Family Justice Initiative, we had a case that I had to file a motion for reunification because the parenting time completely halted and stopped due to the foster mother not interested in providing FaceTime or any sort of video conferencing between the child and mom. And I had to do emergency motion, and what had occurred is the judge found that there was no reason to delay the reunification, and then because of COVID-19, and especially because of the parenting time being stopped due to the foster mother not willing to entertain these alternatives to visitation, he just found that was unnecessary trauma to the child. The child was not seeing her mother, and there was really no reason to delay reunification. Again, mom was at a shelter, but we were able to show this was stable and safe, and we were able to get the child home. There was extensive follow-up emergent motions and hearings after, just to ensure the level of how you would transfer custody and what was needed for the child practically to get back home. But we were able to work that out and be able to line up what was required and needed. So I just wanted to just highlight those two examples that we just had on the ground now and, with COVID-19, but it was still utilizing some of the techniques and examples and guidance that Andrew and Mimi and our office identified earlier. So, and if I'm missing anything, Mimi and Andrew, please let me know. What we have next are two slides, two real examples of case stories, just to hit on, to kind of lead the discussions when you as an advocate, what you should be thinking either pre-petition or post-petition. The first example is called Maria's story. If this is your case, either post-petition or Maria walks into your office, some of the questions that we wanted you to think about when you're trying to be a zealous advocate, an effective advocate, is here Maria comes into your office and she's raising the issues of her son Jose, who's been missing school for over 40 days. And also when the school calls the child welfare agency, it's noted that he has the same clothes and skin rashes. And she's concerned, what are the concerns for Maria if prior to speaking to CPS, and whether this could be a removal case, and what would you ask? So in this case, of course, you would want to know why he's missing school. In this case, there was bullying. There was also issues with the teacher. So we wanted to raise that there are, again, access to protections under the education welfare laws that would protect Jose from being in trouble with the school and raising defenses to the truancy issues, and what was the school doing to advocate for Jose. And that was, this is a real example where we were able to work with the Child Welfare Agency and the school to sort of protect and advocate for Jose, and not have this be an issue of educational neglect or accusing Maria not able to meet the needs of her son. And also there were also mental health issues. There was also need for therapeutic services. That was part of how we serviced that situation, and also prevent Jose being taken away from Maria. What we also learned is that Jose was allergic to the laundry detergent and other issues with the laundry occurring in their apartment building. There was like a lead issue, chemical issue, so it was a shared laundry facility, and that was the reason for the skin rashes and the fact that she was living in poverty, and they were not necessarily wearing the same clothes, but all his clothes just ended up having the same tone and gray tone. And so that was something we were able to resolve and have the landlord assist in getting new washer and laundry services in the building for everyone. So this was just, again, questions to think about, is what we were trying to figure out really, what were the reasons for the educational issues, what were the causes for the clothing issues and the skin rashes, and what it just resulted in. It was not Maria failing as a parent and neglecting her child, and especially was not a reason to, would be a reason to remove Jose from her care. Okay, and then our last example is, again, Hope's story, which is, this is based on the true case, which we've hit on, is an example of her struggling to pay rent and dealing with a pending eviction, and her own anxiety and her own trauma that she experienced growing up in foster care, which is many of our families, many of our parents deal with this and face these issues. And so, again, what type of questions that we wanted to ask is whether she was getting the therapies that she needed, the self-care that she needed, and acknowledging her trauma and understanding her depression and connecting her quickly with effective, beneficial therapies that she could trust and believe in, and that also, as she was afraid, that this information may be transmitted to the agency and be used against her. So this was something she experienced as a youth in the foster care system, but building a place where she can actually have her own independent therapy and not be worried if that information is released. And then again, assisting and advocating on behalf of Hope with the Child Welfare Agency, working with her to assist with rent, and also once the rent insecurity of her house was resolved, she actually was able to start doing some work because we were able to get her daughter into daycare through the assistance of the child welfare system. And again, this was advocating on how to prevent removal. When we got this referral, the caseworker started off with, I really am going to have to remove. We're giving you a week to try to figure this out. It took about 6 months with the Child Welfare Agency to assist Hope, but she's doing well, and her 2-year-old is doing well, but it was just trying to resolve these questions and ask these questions with Hope, and then connecting her with the right resources immediately and putting pressure on the agency to support Hope instead of feeling like a burden or a threat to Hope. I think I hit on this throughout my examples, and if this comes up again in the question, but it's really understanding the prevention work and understanding how to utilize this in post-petition work. I think I'll send it back to Mimi.
Thanks, Jay. And everyone, if you have questions as I'm talking, because we're getting near the end of the hour, please type them in the chat so that Jay or I can chime in. And I think what Jay was alluding to near the end in terms of reasonable efforts and what, being able to do prevention work and how that impacts the work after a child is removed, or in many of the cases in your courts where parents are not appointed counsel until a petition is filed. All of the tools that Jay was talking about, all of the advocacy skills are really important to be able to allow the attorney to be talking to the client before they walk into the initial removal hearing, whenever possible, right? To be able to strategize and figure out, are there things that could be put into place right away so that the child doesn't need to stay in care, and so that you as the judge could send the child home right at that initial hearing. So our colleagues at the Center for Family Representation in New York, they have a construct they call the 4 cornerstones, where the legal team, again, the attorney, the social worker, and the parent mentor, provide intense representation, especially in the first 60 days of the case, but throughout the life of the case. And they focus their advocacy on these 4 cornerstones, on visitation, on placement, on conferences, and on services. Much like what Jay was talking about, how can you frame your advocacy in a way that's most effective, right? Lawyers don't have a whole lot of time or a whole lot of resources. And our friends at CFR have found that when they focus on these 4 cornerstones, they have been incredibly effective in keeping children home when possible, when returning them home as quickly as possible to have permanent reunification. And I like to say that visitation or family time is my favorite cornerstone. And it's something that the federal government and the Children's Bureau focused on in that letter that Jay referred to, which is in your files, in your materials, the importance of family time, preferably in person. These days, many of your families are having their family time virtually, but it's so important for the ongoing life of that family, the strength of that family. And you can see here sort of the language that our friends at CFR use about visitation family time. And the part I love the best is that there should be activities that mimic family life, that when children are visiting, they need to be doing things like eating dinner or having their parents come to a school activity, or these days having a book that they can read together, or watching a movie virtually together, having dinner together, doing things that they would do if they were in the same place, if they were living together as a family. And so I think it's really important for those of you on the phone who are advocates to be advocating for, visitation that is at the lowest level of supervision and that mimics family life, and even if it is virtual visitation. And something else that the letter points out from Jerry Milner and David Kelly is that children aren't going to sit in front of FaceTime for an hour. That's just not happening. So if your family gets only an hour of visitation a week, and hopefully they have more than that, but it could be broken up into 2 half hours or 4 15 minutes. Again, to do something creative like reading a story together, or having the child, if they're old enough, and the parent both step outside, look around, and describe to each other what they see. Doing something that's actually interactive to really be able to maintain their relationship during this really scary time. And we've been hearing about families that aren't getting even virtual visitation right now, and that is just, you all need to do whatever you can do to ensure that families are getting, hopefully in person, but definitely virtual visits, because I've been thinking, how scary it would be for a parent not to have eyes on kids right now, and for the kids not to know if their parent is healthy and well. And so I think we play an incredibly important role in normal times and in this health crisis time of ensuring that. I also wanted to point you to another resource that is in your web links, which is the Standards of Practice for Attorneys Representing Parents. So these standards were written in 2006, and they were the start of what we like to think of as our national movement, our National Alliance for Parent Representation. Jay sits on the steering committee of that National Alliance along with over 30 leaders, parent attorney leaders from around the country. And our movement started by writing these standards of practice. The attributes that I talked about earlier are based in part on these standards and in part on the children's attorney standards. But we've set out some to-dos for those of you who are judges and those of you who are leaders in the court, some activities that really are essential to ensuring high-quality representation by the parents. And some of this was also mentioned by Andrew in your ERG. So I'm so happy that we have consistent language between all of these important documents. But understanding the importance of the parent-attorney role, creating uniform standards in your own community, ensuring appropriate compensation, ensuring that parents' attorneys and children's attorneys have access, like Jay said, to interpreters and to others who can provide the support that the attorneys need to best represent the clients. As judges, ensuring that they have a reasonable caseload, because of course it's malpractice to be handling too many cases and not being able to provide that out-of-court advocacy and focus for clients. And so again, you can read all of them, but you all play such an important role in ensuring high-quality representation and in trying to move your jurisdictions towards the place where Jay's is, which is to be able to have legal representation even before a child is removed from their family. I also just wanted to point out one other resource, which doesn't exactly have to do with high-quality representation, but does have to do with your job as judges, and that is there's a new tip sheet in your web links about conducting remote hearings. So all of you I know are struggling with, can our courts stay open? How can we do remote hearings? Can we only do emergency hearings and not permanency hearings? So my colleagues put together some tips on all of that. I know it's a big topic of conversation with NCJ, FCJ, NCSC, the ABA, and all of you on the ground. And again, it's just so important that clients, that families have access to you as leaders of your community and courts. I heard last week a court in Oklahoma did a full day of remote Safe Babies hearings, and apparently it went really well. Families felt heard and had the opportunity to be able to move their cases forward, even though they weren't all in the same place. They did it through Zoom, and they were able to figure all of that out. So just another little resource to see if it can be helpful. And I actually, I could go on and on about high-quality legal representation. It's one of my favorite topics, but I'm wondering if there are questions. If not, I just, as you're opening up and in the chat, I also just want to remind you, on a last webinar, we had a conversation about 4E dollars for representation. We decided not to get into that today because we wanted to talk about the nuts and bolts. But again, remember that there is access to federal dollars to pay for the improvement of your representation through 4E, and I'm always happy to talk to any of you off webinar about how to make that happen. So Andrew, I think I'll send it back.
Oh, sorry. This is Andrew again. I just wanted to reference that previous webinar that you just brought up is available. It's been recorded previously. We've sent it out through our listserv once before, but if people that are on the line today want access to the recorded webinar that focused more on how to pay for some of this work, we can get that to you as well. And there's contact information for all three of us. If you have specific questions, you can reach out to us individually. And again, I'll point you to the two pods in the bottom right-hand corner of your screen. One is web links, and one are downloadable PDF files. all of which have been referenced during this afternoon's conversation. But if people have questions, feel free. Your phone lines are now unmuted, and you can ask questions out loud, or you can chat them into the chat. We reserved a few minutes at the end to do that. I'm sorry, did somebody have a question?
Where do you pull the virtue signal? I got a landline. Oh, is he?
Well, if nobody has any questions, I'd like to thank you again for your time this afternoon and joining us. Again, our contact information is there on that slide. We also have contact information for OJJDP, who funded our discussion this afternoon. I'd like, again, to thank Mimi and Jay for their time this afternoon and sharing their knowledge and skills with the audience. And we will, as again, this webinar today is recorded. We will send out a link through our listserv with the recorded version of this, so you can all share it with others or watch it again if you'd like. Thank you again, everybody.
Thank you.
Thank you.
Take care, everyone.
Bye.
Bye-bye.